Welcome to Chapter 4, Part 2 of Business Laws. In this session, we will take a closer look at three critical concepts: minors as partners, the dissolution of partnership firms, and limited liability partnerships. These topics are essential for understanding how business relationships are structured and regulated in India. By the end of this chapter, you'll be able to apply these principles to real-world business scenarios. Let's begin with Section 4.5. Minor as a partner. According to Section 30 of the Indian Partnership Act, a minor cannot become a full partner in a firm. However, with the consent of all existing partners, a minor can be admitted to the benefits of an existing partnership. This means the minor can share in the profits but cannot be held personally liable for the firm's losses. For example, imagine a family business where a 17-year-old is allowed to receive a share of profits but cannot make binding decisions for the firm. The process of admitting a minor to the benefits of partnership requires unanimous consent from all partners. This agreement must be documented in a partnership deed or an addendum, clearly stating the minor's share of profits and their rights to access firm accounts. For instance, in a tech startup, the partners may agree to admit the founder's teenage child to the benefits, specifying their profit share and access to annual financial statements. A minor admitted to the benefits of partnership enjoys three main rights. First, to receive their share of profits as specified in the deed. Second, to inspect and copy the firm's accounts. And third, to sue the firm for their share if necessary. For example, if the firm withholds profits, the minor can take legal action to claim their rightful share. Importantly, a minor has no personal liability for the firm's debts. Their risk is limited only to their share in the partnership assets. They cannot represent the firm or bind it through contracts or decisions. For example, if the firm incurs losses, the minor's personal property is protected, and only their share in the firm can be used to cover debts. When the minor reaches the age of majority, they have 6 months to decide whether to become a full partner. This decision must be communicated through a public notice. If they choose to become a partner, they gain full rights and responsibilities. If not, they forfeit their share in the firm. For example, a minor who turns 18 in a family business must make this choice within 6 months, or the law will decide for them. If the person fails to give public notice within 6 months, they are automatically considered a full partner, with personal liability for all acts of the firm since their original admission as a minor. This rule ensures clarity and protects third parties dealing with the firm. For instance, if the now adult partner does not opt out, they become liable for any debts or obligations incurred during their time as a minor beneficiary. Let's look at a brief scenario. Ria, age 17, is admitted to the benefits of her family's partnership firm. She receives a share of profits but cannot sign contracts for the business. When she turns 18, she has 6 months to decide if she wants to become a full partner. If she does not give notice, she is deemed a partner and becomes personally liable for all firm actions since her admission. This example highlights the importance of timely decisions and clear communication in partnership law. Section 4.6 covers dissolution of a firm. Under Section 39, dissolution breaks up the partnership relation between all partners, ending the firm as a going concern. Every partner has the right to wind up the business, pay firm debts, and distribute any surplus according to statutory provisions. A firm can be dissolved in 5 ways: by agreement, compulsory dissolution due to illegality or insolvency, on contingencies like death or term expiry, by notice in partnerships at will, or by court order when a partner becomes incapable, breaches agreements, or conducts business prejudicially. Section 48 establishes the settlement waterfall. First, debts to third parties. Second, partners' advances. Third, partners' capital. Finally, surplus divided by profit-sharing ratio. For example, if a firm has 30 lakh rupees after realization, owing 10 lakh to vendors, 4 lakh in partner advances, and 12 lakh in capital, the remaining 4 lakh surplus is split by profit ratio. Public notice is essential under Section 72 to cut off continuing liability. This includes notification to the registrar and advertisements in the official gazette. The managerial checklist includes final accounts, creditor settlements, public notices, IP handover, tax filings, and archiving records for future evidence. Section 4.7 introduces limited liability partnerships under the LLP Act 2008. An LLP combines partnership flexibility with corporate limited liability protection. Under Section 27, the LLP is liable to the full extent of its assets, but partners are not personally liable for LLP obligations solely by reason of being partners. Unlike traditional partnerships, LLPs have separate legal personality, perpetual succession, and limited liability. However, they require more compliance, including designated partners and annual filings. Choose partnerships for speed and privacy, LLPs for limited liability without full corporate compliance, and private limited companies for equity fundraising and rapid scaling. LLPs are ideal for professional practices where partners want management flexibility with liability protection. The LLP agreement serves as the constitution governing all internal matters. In summary, we've covered how minors can benefit from partnerships without full liability, the systematic process of partnership dissolution, and how LLPs offer modern business flexibility with protection. These concepts form the foundation of partnership law in India.